now in session. Please be seated.
All right, introductions, please. Mr. Reed.
Good morning, Mr. Chief Justice, Justice Valhora, Justice Traynor. John Reed from DLA Piper on behalf of the nominal defendant and appellee SolarWinds Corporation. With me at council table is Michael Biles from the Austin, Texas office of King & Spalding. And then in the gallery is Becky Melton, who is the Vice President of Legal Services for SolarWinds. And we also have Jason Bliss, who's the General Counsel for SolarWinds.
Welcome.
Wait.
Good morning, Chief Justice Seitz, Justice Valhora, Justice Traynor, Kevin Gallagher of Richards, Layton, and Finger on behalf of the Director Defendants William Bach, Seth Barrow, Paul Cormier, Michael Hoffman, Dennis Howard, Catherine Kinney, James Lyons, and S. Warren Sundaram. With me today from Kirkland & Ellis are Stephen Atkinson and Amal El Bakar. And we'll be relying on Mr. Reed this morning. Thank you, Your
Thank
Honors.
you and welcome.
Good morning, Your Honors. Ryan Stopman from Morris Nichols on behalf of defendants below appellees Mike Bingle, Kenneth Howe, Jason White, and Michael Widman. I'm joined by my colleagues from Wilkie, Farr, and Gallagher in New York, Wesley Powell and Patricia Haynes, and we also will be relying on Mr. Reed's argument today.
Thank you very much and welcome.
Good morning. Stephen Childs of Abrams and Bayless on behalf of defendant below appellee Kevin Thompson, and we will be relying on Mr. Reed's argument today.
Thank you. All right, Mr. Barry.
Your Honors, I'll be much shorter. Michael Barry.
That doesn't work against your tongue.
Thank you. Thank you. Michael Barry, Grant Eisenhower. With me at council table is Chad Johnson and Noam Mendel from the Robbins Giller Law Firm. With the court's indulgence, Mr. Mendel, who has been admitted pro hac, will be presenting for the plaintiff's appellant.
Welcome and please proceed.
Thank you.
Good morning, Your Honors. With the court's permission, I'll reserve 5 minutes for rebuttal. Thank you. Thank you, Your Honors, for holding a hearing about this very important case. This is an appeal from the Chancery Court's dismissal of a stockholder derivative suit asserting claims under in re Caremark, as well as under this court's precedents in Stone versus Ritter and Marchand versus Barnhill more recently. The principal theory asserted is a so-called prong one Caremark claim. The thrust of the claim is that defendants failed, utterly failed, to even try in good faith to put into place a system of board-level oversight concerning known mission-critical cybersecurity risks with respect to the company's only line of business. Now, there's no dispute here that the defendants, as board members of SolarWinds, had these duties of oversight, just as there's no dispute that cybersecurity is a core mission-critical issue for this company. Defendants both here and below never disputed this reality. And that's because they can't. Their own documents describe this issue as mission-critical, and our complaint explains why it's mission-critical. This company was in a unique position in the software supply chain as a ubiquitous network manager with special privileged access to some of the highest value targets in the world, and this was in an environment in which any reasonably informed fiduciary understood the growing risk in this space. So they obviously had a duty here, and again, they don't dispute it. So as a result, the key issue here is whether the plaintiffs have pled facts supporting an inference that SolarWinds Board of Directors made no effort to put in place a board-level oversight system concerning this critical issue. And respectfully, plaintiffs submit that the answer to that question is decidedly yes, that the allegations of the complaint are more than sufficient, and in fact, the only reasonable inference to derive from the allegations of the complaint is that the defendant board made no effort to put in place any sort of board-level system of oversight whatsoever concerning cybersecurity at this company.
Do you agree that this case is a little bit different than The typical Caremark case, and I think your friends would say, no case is imposed oversight liability based solely on a failure to monitor a business risk. So would you agree that you're asking us to essentially widen the scope of Caremark as it presently stands?
I would not agree that we're asking the court to widen the scope of Caremark. Marchand makes clear, a reading of Marchand along with the other authorities from this court as well as the Chancery Court, makes clear that there is a distinction between generic business risk and mission critical risk, issues critical, fundamental to a company, that are these larger mission critical risks, critical to the mission of the corporation. And these sorts of business risks are fundamentally different. And the notion, it seems to be that the notion that there's a requirement that there be some sort of positive law is the language used by the court below and is the language used by defendants in their brief, that there needs to be some sort of positive law governing the relevant area for there to be Caremark liability. I don't see support in this court's decisions for that rule. Marchand is actually quite explicit that the Caremark duties apply with respect to operational viability, legal compliance, and financial performance. So the decision is explicit in referencing areas outside of the area of legal compliance and positive law.
I'd like to follow up on that question and focused on the nature of the risk. It seemed to me that the Vice Chancellor placed a certain amount of emphasis on the fact that the source of this particular risk was outside criminal actors as opposed to something under immediate control of the company. Is that a relevant consideration?
Well, I don't think it's a relevant consideration to the extent that the complaint pleads what it needs to plead with respect to the question of causation. I take this to be a causation point, that anything that the defendants would have done, regardless of what oversight they would have done, the outcome would have been the same. The Russian spies are too powerful and the same result would have applied. For pleading purposes, and this is in Marchand as well, there's got to be sort of a fair connection between the alleged failure of oversight and the harm that ultimately occurs, right? If the allegation is that there was a failure of oversight vis-a-vis cybersecurity, and the harm that's alleged is that an earthquake struck the corporate headquarters and ruined it, obviously there's no claim there, there's no connection there. But here we're pleading quite a clear chain of causation between deficient cybersecurity that's permitted to exist and persist and fester under a board's failed oversight, particularly with respect to password protections and things of that nature. And we ultimately see an invasion from an outside entity that it is now admitted by the company used passwords and took advantage of the company's deficient password security systems as the point of entry. So this complaint pleads quite a clear chain of causation between these events, and for purposes of pleading, to find otherwise, you'd really need to draw inferences in favor of the defendants that this was impossible to prevent, but for measures that these defendants couldn't have taken or anything like that. And I think that the record really shows that the reality is that very mundane cybersecurity types of systems and protections that are, increasingly standard for all American corporations would likely have been able to prevent this, would have hardened this target, and the failure of the board to conduct oversight allowed the system to fester and made this company a vulnerable, soft target for a type of cyber attack that is a known risk in this area and was known to this board and is well understood. So the fact that an outsider human invaded this company rather than a germ, as was the case in the Marchand decision, really shouldn't make a difference, certainly not when, for pleading purposes, the complaint really does plead a very direct, simple to understand chain of causation. And you'd have to draw inferences in favor of the defendants and accept their arguments that nothing would have made a difference, and we should be entitled to discovery to prove this claim. Have I answered your question, Your Honor?
See.
If I may continue with respect to this positive law point, look, it cannot be the law that simply because something is governed by law, it is mission critical for a corporation, right? The context really matters. The DuPont Corporation, I presume, has cafeterias where they serve food to their workers. And those cafeterias and that food service is presumably governed by all manner of law, federal law, local law, state law, multi-jurisdictional laws probably apply to this. I don't think anyone is seriously arguing that the board of directors of the DuPont Corporation would need a food safety committee simply because the issue is governed by law. But the Bluebell Corporation needed to conduct oversight at a board level with respect to food safety because food safety is an essential mission critical issue for that company. And the Marchand decision is clear on this point. The Marchand decision says that the issue was that they had to make their product safe to eat, not safe to eat because the law requires them to make it safe to eat, or safe to eat because there are some regulations in place. Context really matters in determining what is or isn't mission critical. Of course, you're often going to see that areas that are mission critical for corporations are governed by positive law, particularly where there are public health and safety issues at play, but that's not always going to be the case, particularly in areas of new technology. And it just simply makes no sense to have a law that mission critical things can only be those things that are governed by law. And again, Marchand, in fact, in Marchand, the court addressed a very similar issue where the defendants in that case argued that there could be no claim because the company was in compliance with certain FDA regulations. And the court held very specifically that that was not determinative in the case, that whether the company was in compliance with certain existing laws was irrelevant to the question of whether this was a mission critical issue subject to board oversight. As the court wrote, but the fact that Bluebell nominally complied with FDA regulations does not imply that the board, emphasis in original, implemented a system to monitor food safety at the board level, again, emphasized in the original. So I don't know if I'm answering your question, Your Honor. I intend to be.
I have another question.
Please.
The part of what you complain about is that the audit committee and the other committee that was receiving reports didn't report up to the board of directors for quite some period of time. What is your position with respect to what extent can a board of directors delegate to a committee the oversight responsibility? You're not saying that that's not appropriate, are you?
So there's a lot of responses to this question. One, I think the court below misconstrued our complaint in this regard. The court wrote that he takes our complaint to be that he should find bad faith because the committees never reported to the board. That is not the crux of our allegation. That is not the crux of our theory. The theory is, and the complaint I think is irreconcilable with that view of our claim. The theory is, that is alleged in the complaint, is that the directors of this corporation, both at the board level as well as at the committee level, did not carry out their obligations here, did not in good faith attempt to put in place a system of oversight. Now, as to the board, the court seems to find that this nominal, what I will describe as a nominal delegation of authority to committees, the simple fact that committees are assigned responsibility for oversight over a particular area is insufficient to satisfy the obligations of the board at the board level with respect to mission critical issues. There's no support in Marchand or otherwise for this notion that with respect to a core risk facing a company, the board of directors can simply assign some subset of themselves to take care of it and forget about it. Never hear about it again, never inquire about it again, never receive reports from management, never have a schedule for discussing it, any of these things. That is insufficient with respect to a mission critical risk. You cannot simply delegate it away, and put it on oversight, and put it on autopilot. But beyond that, the complaint alleges that both of the committees didn't carry out this obligation. The audit committee had a specific, from the time of the IPO in 2018 through present, as far as I know, through Sunburst and the discovery of Sunburst, the audit committee had a specific duty to carry out oversight with respect to cybersecurity. And the audit committee never did that. The court appears to infer that the audit committee did carry out this obligation, and that the question then becomes, well, that I'm raising a claim about whether they were supposed to be reporting it to the board at large. That is not the allegation here. The 220 materials that we received here showed that in the history of this company, despite an explicit express obligation to be carrying out cybersecurity oversight, the audit committee never did it. Never received any reports from management, never had a schedule to receive any reports from management or to otherwise discuss the issue, never reported to the board or discussed the issue amongst themselves, or there's just no indication in the documents provided by the company that the audit committee ever carried out this obligation. So it goes beyond this question of can the board delegate authority, and forget it. The delegees of this authority on the audit committee in particular never carried out this obligation. And there's also another committee, the Nominating and Governance Committee, and the uncontradicted record here is that the audit committee, the Nominating and Governance Committee, shortly after the IPO, conducted a single meeting concerning cybersecurity. That meeting contained some pretty vivid warnings about exactly the type of attack that ultimately occurred. And for a 2-year period thereafter, that committee never touched the issue again. Never heard from management, never required reports from management, nothing of the sort. That is a total failure of systematic oversight. And I'll point out that in November of 2019, there was a major cybersecurity incident that took place here. This is the SolarWinds 123 incident, and it's very easy to sort of laugh that off. Say, oh, it was a poor password, SolarWinds 123. The gravity of this security breach is hard to overstate. This was not just a poor password. This was a poor password for the software download website of the company, where customers go to download software. The code for this was set by an intern. The intern put the code as SolarWinds 123, and that was ultimately leaked and posted on GitHub, which is a forum where hackers and security professionals and the like in the cybersecurity space are known to congregate. And the company didn't even know this until an outside third-party malware hunter brought it to management's attention. And yet it's never reported to the board. This is a giant red flag that takes place in the middle of this period that we're talking about here. And there is no indication that it was ever reported to any of these committees, that it was ever reported to the board, and there's no indication that there was any requirement, let alone to make regular reports by management to the board, but that there was even a requirement to report major security incidents, emergent situations. There was no requirement that management reported to the board, and management, it looks like, did not report it to the board. It brings to mind the analogy used at the argument in Marchand with respect to the child in school who gets an A in gym and gets F's in math and social studies and all these things, and it's at that child's discretion what to report to his parents, and so he tells them when he gets an A in gym and doesn't mention the other things. Lo and behold, the child is failing out of school 2 years later, and everyone's wondering, well, what happened? Well, what happened was that there was no oversight system in place. The hallmarks of an oversight system, as this court articulates in Marchand, are mandatory reporting from management and a schedule for that reporting. Mandatory periodic reporting concerning mission critical issues. And the company here failed, both at the defendants here, I should say, failed both at this committee level and at the board level at large to carry out this obligation. And as we explain in the complaint, you get to a majority of conflicted members of the demand board, whether you count heads at the board level for what we submit as a total failure in good faith to act with respect to this issue, as well as if you count heads from the committee perspective when you include people who are conflicted from with conflicts vis-a-vis existing boards. For example, you have a board member who is a defendant board member who is a Silver Lake person. And that individual is no longer on the demand board, and someone else from Silver Lake has rotated in. That individual can't reasonably be expected to sue their compatriot from Silver Lake, who is a defendant in the case. So either way you carry out the analysis, and this is all in our complaint and in the papers, you get to a majority conflicted board for purposes of demand futility. And to simply focus the inquiry on reporting from committees to the board is wrong and insufficient and inconsistent with the allegations of our complaint. I see that my orange light is on, and I've spoken longer than I intended to, and so I will save 2 minutes for rebuttal. Thank you, Your Honors. Thank you.
May it please the court. I know the court has thoroughly reviewed the briefs and the opinion below, and I know the court's well-versed excuse me, on Caremark law. So, because I can assume that knowledge, I really do want to get right to the point. First on the law, and then on application of the law to the plaintiff's allegations. And I've identified what I think are the likely issues or questions the court will have. And I want the court to know that I came up with those all by myself and without any assistance from AI. The plaintiffs did not make a demand on the board. So as the court knows, this is not an entire fairness case or a personal benefit case, so that they have to satisfy the second question in this court's 3-question Zuckerberg test with respect to demand futility. And that question is whether a majority of the directors, quote, face a substantial likelihood of liability. I wanted to start with a standalone discussion of the law here, because consistent adherence to our fundamental principles is important to our stability and also the predictability for which we've come to be known. Some practitioners have suggested that Marchand tweaked the law and weakened the pleading requirements for an oversight claim. They also then point to the subsequent Boeing decision from the Court of Chancery as evidence of that being the case. I submit to this court that our law has been consistently applied since Caremark was issued 25 years ago, and that this court's decision in Marchand was a straight-up application of Caremark. In Caremark, Chancellor Allen was very clear that you must plead facts establishing bad faith to proceed on an oversight claim. And Caremark held that only, quote, only a sustained or systematic failure of the board to exercise oversight will establish the bad faith necessary to proceed. Now, 10 years after Caremark, this court issued its opinion in Stone versus Ritter. And under a heading titled Caremark Standard Approved, this court held that a culpable state of mind is necessary to establish bad faith. The court also expressly used the language Caremark used, in that a necessary condition to a bad faith claim in an oversight case is a sustained or systematic failure. That was a wholesale adoption of Caremark. Now, besides clarifying that the duty of good faith is a subsidiary duty of the duty of loyalty, what was so significant about Stone versus Ritter is that it articulated the situations that can lead to a sustained or systematic failure. They are, 1, an utter failure to have any structure or system in place that gets information to the board, or 2, a disregard of red flags that leads to harm to the company. Those 2 conditions can lead to a sustained or systematic failure that causes harm. But our law has never deviated from the requirement that there be a sustained or systematic failure. A one-off doesn't satisfy the law. And look, this is the exact standard. The law I just went through is exactly what this court applied in Marchand. In the very first paragraph of the court's analysis under the Caremark claim, this is what the court said, quote, to prevail on a Caremark claim, the plaintiff must show that a fiduciary acted in bad faith. The state of mind traditionally used to define the mindset of a disloyal director. Marchand did not in any way weaken the pleading requirements. Even a cursory review of the pleading in that case and the opinion shows that it was well within Caremark and Stone versus Ritter. Listeria was a known threat in the food industry. That's why it was regulated. Yet Bluebell Creameries had no board committee that addressed food safety and no reporting at all. Over a period of years, there were 15 instances of Listeria breakouts and FDA regulation violations. None of them was reported to the board, and it was the 16th outbreak that led to liability. That was certainly a sustained or systematic failure. It's of the type contemplated, maybe even more than what was contemplated by Caremark, but it's the kind of conduct that shows a culpable state of mind.
Mr. Reed, are you heading in the direction that the mere establishment of a committee defeats a claim of a systematic failure?
No, not at all. I mean, there has to be some reporting.
It has to be a functioning committee.
Yeah, there has to be some form of reporting that gets to a committee of the board. It doesn't necessarily have to be the full board unless there's something material that maybe does have to go all the way up to the full board, but I think reporting to a committee is sufficient. Look, the Boeing case was no different here. In the Boeing case, there was no oversight on airplane safety. Despite multiple regulatory violations, multiple 10-figure settlements, and plane groundings, there was no oversight. And then there was an accident in 2018 that killed 189 people caused by a defective sensor. That accident then was never investigated. Then there was a second accident that led to the viable claim that killed 157 people, and it was caused by the exact same sensor that the board never investigated. Look, I wanted to walk through that law as background before getting to the facts, because it demonstrates that it's not a corporate trauma or the magnitude of the corporate trauma that creates liability. It's whether or not the trauma was caused by a sustained or systematic failure of the directors. That's what's necessary to show the culpable state of mind and to charge the directors with bad faith. Before turning to the Caremark analysis, I just want to make a few points about what actually happened here. Look, SolarWinds was the victim of a cyber attack. That was a crime committed against SolarWinds because of its clientele, which included a number of government agencies and all 5 branches of the military. This was probably the most investigated cybercrime in history. And ultimately, the US government concluded that the Russian Foreign Military Service injected malicious code into the software. It was called Sunburst. And then once installed, they were able to gain backdoor access to the clients. After months of investigation, there were Senate hearings on this. And during those hearings, this attack was described by the president of Microsoft as, quote, the largest and most sophisticated cyber espionage operation in history. He then testified that, quote, we haven't seen this kind of sophistication matched with this kind of scale. And he estimated that it took, quote, at least 1,000 very skilled, capable engineers. Now, nothing in plaintiff's complaint contradicts what happened with respect to this attack. And nothing like this occurred to SolarWinds before, or any company on the face of the earth before, for purposes of putting somebody on notice of the scale of this kind of an event. Let me turn.
Mr. Reed,
yes.
can I interrupt you just to?
You can interrupt me as much as you want, Your Honor.
What I was thinking about is your friends cite to this February 19th, 2019 report and the April 2020 presentations to the committees. And I think you say in your brief, the company made each of these reports for the specific purpose of apprising the board of ongoing cybersecurity risks. But the full board apparently was never apprised, and over a period of years. And so my question is that actually a reporting system? And can that sort of lack of communication between the community to the committee to which the responsibility has been delegated and the board, can that lack of communication rise to a level of bad faith if it goes on for a sustained period of time?
Well, to answer your latter one first, I think a lack of communication, if there were problems that were occurring and were simply not being brought to the full board's attention, yes, I think that could result in liability. During this entire period, from the first meeting in February of 2019 through to the audit committee meeting in April of 2020 and then the incident in December, there were no material incidents to report. So let me address one of the questions I flagged.
I understood your friends is to identify the password problem as an intervening incident.
Well, I can address that now. So I think that really applies. That's sort of almost a prong 2 analysis. And the weak password is a one-off user error. It was not a defect in the operation of the business, and it was immediately fixed. What's important about this is this was a password for a third-party server. Now, that server was not being used anymore, and it was not used to download the Orion software. That last sentence I just gave you, I can't give you a record site for it. But what I would say is the plaintiffs never plead, because they can't plead this, that 123 password was in any way connected to the Sunburst incident here. They do not plead that the software was either uploaded or downloaded
I didn't
from that
understand
third-party
that
server.
to be their point. I understood their point, you can call it prong two, it was a red flag. It was indicative of an oversight problem.
Well, respectfully, I don't think it's indicative of an oversight problem. It was indicative that somebody picked a weak password and it was fixed. I mean, no different than if an employee had given somebody else a password. It's a one-time user error. It's not a problem with the operation of the business or the monitoring of the cybersecurity or all the things that they were doing that they talked about in that 2019
Couldn't it be said
presentation.
that it is indicative of inadequate cybersecurity?
Respectfully, Your Honor.
Leaving aside how grave a problem it might be,
Well,
cybersecurity experts would probably tell you not to do those things, correct?
yes, I think that they would tell you, but it's still not a problem with their cybersecurity. It was a user error problem. I mean, and cybersecurity continues to evolve to this day. I mean, there's no company is a guarantor of avoiding an attack like this, despite everything we know even today. Now, if I may return, have I answered your question? And I'm going to get to a couple more points on that when I get to the second prong. They say that we failed to actually monitor cybersecurity, that there was an utter failure here. Now, before I turn to that 2019 presentation, I guess the question in my mind that comes up here is, what does our case law mean when it says a system of reporting? Our case law has never mandated some kind of formal, detailed written policy or a decision matrix or a flowchart. As a matter of fact, in Marchand, this court observed that, quote, directors have great discretion to design context and industry-specific approaches. Now, this court used the phrase system of controls. And in the Boeing case at page 26, what the court there used was the phrase board-level structures. We know here that there were board-level structures to get information. SolarWinds Nominating and Governance Committee was charged with responsibility for governance risk, including cybersecurity. The Audit Committee was charged with cybersecurity oversight. As a matter of fact, the things that they say are red flags, most of them with the exception of SolarWinds 1, 2, 3, are actually contained in the report that went to the committee. Here's what's interesting. If you look at your Marchand decision at page 813, this court expressed concern that the Bluebell Board did not have any expectation that management would deliver compliance information or any kind of reports to the board with respect to food safety. That's not the case here. The Nominating and Governance Committee minutes alone show that the directors on that committee had a reasonable expectation that they were getting the information that they need. If you look at B78 of the record, they reported 94 incidents, none of which were material. If you look at B80 of the record with respect to that report, it says that the controls that they had in place were consistent with guidance from the National Institute of Standards and Technology. Those measures included next generation firewalls, endpoint protection and encryption, data leakage protection. The list goes on and on. There was also an improvement plan identified in there at B81. And so I don't know how they can say that there was a prong one violation here given that. Then we have the audit committee. Now, it's interesting, they say at page 10, footnote 5 of their reply brief, that you shouldn't consider that because we produced it after they filed their complaint. But what's important here is we produced that before they had to respond to our motion to dismiss. We can't pretend like that didn't happen. And it's in the record, it's B110, and the court below actually discussed it on page 29, footnote 118. The court just said it would not have changed the analysis here. And what's important, again, there was never, at any time, a material cyber event that was not reported to a committee or the board until Sunburst. And the event that would have put somebody on notice like that cannot be the event that results in liability. It has to be a sustained or systematic failure. There was no utter failure of the board to do anything here with respect to cybersecurity. They had every expectation that information was getting to them. As a matter of fact, when sunburst occurred, it was immediately reported to the board. Unlike in Boeing, which took over a week before they even reported information on the plane crash, and in Marchand, there was a several-year period where there were all kinds of material events taking place that were never reported. So this case is very, very, very different. Let me also make a comment on this with respect to cybersecurity itself. We have the Sorensen case, which is I refer to as the Marriott case, issued by the Court of Chancery, where Marriott was the subject of a cyber attack, and information on over 500 million customers was stolen. The court, at page 13 of that opinion, said that because the directors received reports on cybersecurity risks and mitigation, the directors, quote, surpassed Caremark's baseline requirement that they try in good faith to put a reasonable compliance and reporting system in place. The court also emphasized that, quote, the growing risks posed by cybersecurity threats do not, however, lower the high threshold that a plaintiff must meet to plead a Caremark claim. I would submit that there was no utter failure here. Let me turn to the second prong of Caremark before I run out of time. Our courts have only found red flags where there was clear notice. And if you look at all the case law, it's been clear notice where there have been some kind of law or regulatory violation with respect to the running of the business. Now, they argue that this 2019 presentation should have alerted the board to problems. But if you look at it, it actually reveals the opposite. It reveals that there were no mission critical problems, nor did they identify any material events, as I had mentioned. The most they can point to with respect to that report is the part of it where it talks about SolarWinds being an attractive target and that someday might face a sophisticated adversary. But that presentation, if you look at B79, notes that there were no current, quote, no current signs of SolarWinds being the focus of targeted attack groups. Court of Chancery in the Hamrock case that we cite says that general risks are not red flags of a specific corporate trauma. And Chancellor Bouchard in the Reader case said that escalating compliance risk may be a yellow flag, but it's not the kind of red flag that we recognize under our Caremark law. Let me make sure that I have, Justice Traynor, addressed all of your concerns with the Solar123 password. So, again, they failed to plead anywhere in the complaint that Solar123 password was connected to what actually happened here. And if you look at their allegations suggest the opposite, because what happened here was password spraying, and password spraying would not have been necessary if this server was accessed through that one-time server or that password that was posted on the internet. And again, there is not a single allegation, because it can't be made, that the affected Orion software here was uploaded or downloaded from that third-party server. There's also a suggestion that there should have been more meetings. They say, well, look, there was a meeting of the nominating committee in February of 2019. They ignore the fact that there was a meeting of the audit committee in April. But I can say with confidence that if they had held a meeting every month, there would have been nothing to report as far as a material event to give them any indication that this could happen. They had every expectation, to use the language in the Marchand case, that they were getting the information that was necessary. There just wasn't anything to report. It's also not clear what they could have done, even if they had some inclination that somebody was going to try to do something like this. I mean, as we said, it took over 1,000 people. It took a while to detect. It was a very, very clandestine and sophisticated group. And our law just doesn't punish directors because they can't protect their company from cyber crimes. Look, Caremark liability arose because companies have to often navigate highly regulated areas, but you know what the law is. You know the business environment. You know the regulations. Our law has never been applied to a situation where you have ever-evolving and changing criminal tactics, which is exactly what happened here. And we're talking about imposing personal liability. That's our law. I don't see anything in our law that would suggest you would impose personal liability on directors in a circumstance like this. And with the last couple seconds, what I would like to point out is that they say this case is functionally indistinguishable if, Russian hackers had genetically engineered may I finish my sentence?
Sure, sir.
I will finish my sentence. If Russian hackers had genetically engineered a Listeria-type virus and put it into Bluebell Creameries, I think that case might have been decided differently.
Thank you very much, Mr. Reed.
Thank you, Your Honors. Unless the court has any questions, I'll do my best to rebut some of the points my friend just raised.
Since you invited us.
Please.
There's a durational difference here between, as compared to Marchand. Is that, you seem to be hyper-focused on the period between February of 19 and December of 20. The failure in Marchand lasted much longer than that. Is that something we should be thinking about?
Well, respectfully, Your Honor, I'm not so sure that that's correct. The 220 demand in Marchand covered a period between 2 and 3 years in length. That was evident from the oral argument in Marchand, which I watched in preparation for this. There was an almost 3-year period at issue in the 220 demand there. We're talking about a 26-month period here. This is not an appreciable difference for purposes of what we're talking about here. A 2-year period versus a slightly longer than 2-year period versus a slightly less than 3-year period. We're talking about a desert of oversight. We're talking about, my friend refers to sustained and systematic failures are the only ways in which liability attaches in these instances. A 2-year failure to address an obvious mission-critical risk to the company is a sustained and systematic failure. So I don't think that we're talking about too short a period of time here for purposes of this analysis. In fact, it's quite similar to the period of time at issue in Marchand. I'd say further that my friend talks about stability and predictability and adherence to precedent and so on and so forth. And I'd respond that fidelity to a very recent decision in Marchand, which is very clear on many of these points and is, really very much an analogous scenario on all fours with this, that stability and predictability of the legal system requires adherence to that precedent and following that precedent. And that precedent very clearly dictates the outcome here. My friend says that that we must have some very heavy showing of bad faith here in order for the claim to survive. As Marchand wrote, as written in Marchand, a board's utter failure to attempt to assure a reasonable information and reporting system exists is an act of bad faith in breach of the duty of loyalty. The point is that directors have an obligation this is the bottom line in Marchand, to try to make a
Thank you very much. We appreciate the arguments, and we'll take the matter under advisement.
Thank you, Your Honor.